Good evening, beautiful people. Thank you for joining us this evening. I hope you're having a fantastic day and week. Welcome to our weekly YouTube readings of the final report of the California Reparations Task Force right here on the CJEC YouTube channel. The final report for the first in the nation California Reparations Task Force is one of, if not the most important government reports about the Black American community since the 1960s. Equally important, it's also the foundation for current and future reparations legislation in California. The California Reparations Task Force worked for 2 years creating this report that documents historical atrocities against the descendant community across California and the United States. The report is nearly 1,100 pages long, and we're bringing you every page of it, chapter by chapter, every week on Thursdays at 7 p.m. Pacific Standard Time, so that you are properly educated in your advocacy for reparations in California. The task force made nearly 120 policy recommendations detailed in this final report. Today's reading of the final report is presented to you as a community service with support from the Reparations Organizing and Mobilizing Team at the Coalition for a Just and Equitable California, CJEC. CJEC is California's leading grassroots organization born for reparations and reparative justice for Black American freedmen living in California. For more information on CJEC and our work helping to enact the law that created the California Reparations Task Force, California's law requiring state agencies to collect data on descendants of U.S. slavery, the Act to End Current Slavery in California State Prisons, the California Freedmen Affairs Bill, and more, visit www.cjec-official.org. Before we go any further, right now I ask you to do 3 things. Like this video, hit the bell for reminders, subscribe to our YouTube channel. After we're done reading tonight, I will ask you to do 3 more things. Get connected. Follow CJEC on all social media, Instagram, TikTok, Facebook, and X, formerly known as Twitter, at CJEC Official. Get informed. Visit www.cjec-official.org and sign up for current and accurate California reparations news and information on our Get Involved page. Get involved. Support our work by volunteering and or donating. To donate, just click the Donate tab on the home page of our website. A special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. They are a 501c3 organization. To learn more about them, visit www.cabwhp.org. By way of introduction, my name is Raphael H. Plunkett. I live in Southern California. I'm originally from Chicago, and I'm a volunteer reparations advocate with CJEC's Reparations Organizing and Mobilizing Team. The agenda for today, continuation of Chapter 15 of the final report of the California Reparations Task Force. The title of the chapter we're reading tonight is Examples of Other Reparatory Efforts. We continue on page 569, section 3, Domestic Reparatory Efforts. You can follow along in the reading, download tonight's chapter, or the full final report yourself by going to our website at www.cjec-official.org/reports. Okay, we're about ready to start our reading, but before we do so, I have some special announcements and thanks to make. First of all, I'd also like to thank our good friends at ETM Media Group on YouTube for their live readings of the first California Reparations Report. You can watch and listen to their readings of the first report on their channel at ETM Media Group on YouTube and on our website at www.cjec-official.org/videos. Second, today's sponsors are the Plunkett and Bell families in honor of Joyce Agnes Richmond of Chicago. Joyce Agnes Richmond was the mother of 5, a lifelong educator, a community relations liaison for the city of Chicago, and a longtime employee of the Chicago Board of Education. I love you, Aunt Joyce. Rest in power. I volunteer with CJEC for my ancestors, my elders, myself, my children, my grandchildren, and my community. Third, for those of you who don't know, historic reparations legislation in California is here, and more is coming. SB 490 is California's first lineage-based reparations-related legislation to establish the California American Freedmen Affairs Agency. The bill was introduced by State Senator Stephen Bradford and will move forward in 2024. To read the bill, visit www.cjec-official.org/advocacy. Fourth, as mentioned, more historic reparations bills are coming. Over the next several months, more reparations bills will be written. During the 2024 legislative session, we'll see those bills introduced and start moving toward passage by majorities of both the California State Assembly and Senate. To pass reparations bills in 2024, we need 41 Assembly members and 21 senators to say yes. When those bills are passed, we need our governor to sign the bills. So to make reparations a reality in California, the math is 41 plus 21 plus 1. That's 41 Assembly members, 21 senators, and 1 governor. 41 plus 21 plus 1 equals reparations in California. Last but not least, a special thanks to CJEC's Reparations Organizing and Mobilizing Team, specifically our volunteer final report readers. I, Raphael Plunkett, personally extend gratitude to Chris Lodgson for his focus and leadership. And without further ado, Chapter 15, Section 3 of the California Reparations Task Force's final report. Tuskegee's study of untreated syphilis in the Negro male. From 1932 to 1972, in Macon County, Alabama, a medical study observed the natural history of untreated syphilis in African American men. Following revelation of the study, a class action lawsuit was filed against the federal government that resulted in a settlement of nearly $10 million, which was divided among the study participants and their families. In 1974, the federal government enacted legislation to require regulations to better protect human subjects in biomedical and behavioral research and issue a formal apology to the surviving syphilis study victims. From 1891 to 1910, around 2,000 white patients with syphilis were admitted to a Norwegian hospital under the care of Professor Caesar Beck, the head of the hospital's skin department. Professor Beck held the belief that one should wait for the natural course of the disease and refrain from drug treatment. Professor Beck documented the diagnosis and the clinical course in detail in all his patients, and the materials gathered from this clinical trial form the basis for current knowledge about the course and prognosis of syphilis infections. The work of Professor Beck and his successors eventually culminated in the 1955 dissertation referred to as the, quote, Oslo Study of Untreated Syphilis, end quote. The significance of these findings served as the precursor to the Tuskegee study of untreated syphilis in the Negro male, conducted in Macon County, Alabama, between 1932 and 1972 on the campus of the Tuskegee Institute. Quote, in particular, it was the relative frequency of cardiovascular affections compared to neurological affections in patients with advanced syphilis that interested the Americans. In the eyes of the Americans, the weakness of the material justified a prospective study, while they were also interested in discovering whether the findings would be the same with the Negro, end quote. The United States Public Health Service Syphilis Study, also called the Tuskegee Study of Untreated Syphilis in the Negro Male, was introduced to observe the natural history of untreated syphilis in African American men. A total of 600 African American men were enrolled in the study and told by researchers that they were being treated for, quote, bad blood, end quote, which colloquially in the region referred to a number of diagnosable ailments, including but not limited to anemia, fatigue, and syphilis. The African American men in the study were only told they were receiving free health care from the federal government of the United States. Of the 600 enrolled men, most of whom were poor and illiterate sharecroppers, 399 of them who had syphilis became part of the experimental group, and 201 became part of the control group. The men were enticed and enrolled in the study with incentives including medical exams, rides to and from the clinics, meals on examination days, free treatment for minor ailments, and guarantees that provisions would be made after their deaths in terms of burial stipends paid to their survivors. Although there were no proven treatments for syphilis when the study began, penicillin became the standard treatment for the disease in 1947. However, the medicine was withheld from both groups enrolled in the study, resulting in blindness, deteriorating mental health, and in some cases, severe health issues and death. Following the leak of the study and subsequent reporting by the Associated Press in July 1972, international public outcry led to a series of actions taken by U.S. federal agencies. The Assistant Secretary for Health and Scientific Affairs appointed an ad hoc advisory panel comprised of 9 members from fields including health administration, medicine, law, religion, and education to review the study. The panel ultimately concluded that there was evidence that scientific research protocol routinely applied to human subjects was either ignored or deeply flawed and thus failed to ensure the safety and well-being of the men involved. Specifically, the men were never told about or offered the research procedure called informed consent. Researchers had not informed the men of the actual name of the study, its purpose, and the potential consequences of the treatment or non-treatment that they would receive during the study. The men never knew of the debilitating and life-threatening consequences of the lack of treatments they were to receive, the impact on their wives, girlfriends, and children they may have conceived once involved in the research, and there were no choices given to the participants to quit the study when penicillin became available as a treatment and cure for syphilis. 1 month after the panel's October 1972 findings, the Assistant Secretary for Health and Scientific Affairs officially declared the end of the Tuskegee study. Following the ad hoc advisory panel's findings in October 1972, attorney Fred Gray filed a class action suit on behalf of the men in the study, their wives, children, and families, resulting in a nearly $10 million out-of-court settlement in 1974. Under the 1974 settlement, 70 living syphilitic participants received $37,500 each. The 46 living men in the control group received $16,000 each. The 339 deceased syphilitic participants received $15,000 each. The deceased members of the control group received $5,000 each. Attorney Gray also negotiated free health care for life for the participants who were still living, as well as health care for their infected wives, widows, and children. Attorney Gray was not able to locate 36 syphilitic participants and 8 members of the control group. In 1974, Congress passed the National Research Act and created the National Commission for the Protection of Human Subjects of Biomedical and Behavioral Research to study and write regulations governing studies involving human participants. The commission was directed to consider 1. The boundaries between biomedical and behavioral research and the accepted and routine practice of medicine. 2. The role of assessment of risk-benefit criteria in the determination of the appropriateness of research involving human subjects. 3. Appropriate guidelines for the selection of human subjects for participation in such research. And 4. The nature and definition of informed consent in various research settings. In 1976, the Commission published the Belmont Report, which identified basic ethical principles and guidelines to address ethical issues arising from the conduct of research with human subjects. The Belmont Report attempted to summarize the basic ethical principles identified by the Commission in the course of its deliberations. In applying the general principles, the Belmont Report established new requirements for the conduct of research, including informed consent, risk-benefit assessment, and the selection of subjects of research. Following the Belmont Report, the Office for Human Research Protections, OHRP, was established in June of 2000 within the United States Department of Health and Human Services to oversee clinical trials. The OHRP replaced the Office for Protection from Research Risks, OPRR, which was created in 1972 and was part of the National Institutes of Health. OPRR had primary responsibility within the U.S. Department of Health and Human Services for developing and implementing policies, procedures, and regulations for the protection of human subjects involved in the research. OPRR and its successor agency was created to lead the Department of Health and Human Services efforts to protect human subjects in biomedical and behavioral research, and to provide leadership for all federal agencies that conduct or support human subject research under the federal policy for the protection of human subjects. To further protect patient interests and to ensure that participants are fully informed, Section 474 of the National Research Act also established institutional review boards. Institutional review boards were established at the local level consisting of at least 5 people, including at least 1 scientist, 1 non-scientist, and 1 person not otherwise affiliated with the institution. No human subjects research may be initiated, and no ongoing research may continue in the absence of an institutional review board's approval. In February of 1994, at the Claude Moore Health Sciences Library in Charlottesville, Virginia, a symposium was held entitled, quote, "Doing Bad in the Name of Good, the Tuskegee Syphilis Study and Its Legacy," end quote. The one-day symposium featured 7 humanities scholars discussing the Tuskegee syphilis experiments, their troubling historical reality, and their legacy. Following the symposium, the Tuskegee Syphilis Study Legacy Committee was formed to develop ideas that had arisen at the symposium. The committee issued its final report in May 1996, presenting 2 goals. 1, to persuade President Bill Clinton to apologize to the surviving study participants, their families, and to the Tuskegee community. This apology is necessary for 4 reasons: the moral and physical harm to the community of Macon County, the undeserved disgrace the study has brought to the community and Tuskegee University, which is in fact a leading advocate for the health of African Americans, its contribution to fears of abuse and exploitation by government officials and the medical profession, and the fact that no public apology has ever been made for the study by any government official. 2, to develop a strategy to redress the damages caused by the study and to transform its damaging legacy. This is necessary because an apology without action is only a beginning of the necessary healing. The committee recommends the development of a professionally staffed center at Tuskegee for public education about the study, training programs for health care providers, and a clearinghouse for scholarship on ethics in scientific research. The committee's report set forth an outline for the context of the apology and provided possible functions for the proposed Tuskegee Research Center. On May 16, 1997, President Bill Clinton formally apologized and held a ceremony at the White House for surviving Tuskegee study participants. Along with the apology, President Clinton pledged $200,000 planning grant to allow Tuskegee University to pursue building a Center for Bioethics in Research and Healthcare. The president also announced the creation of bioethics fellowships for minority students and extended the life of the National Bioethics Advisory Commission until 1999. Additionally, the president directed the Health and Human Services Secretary to draft a report outlining ways to better involve all communities, especially minority communities, in research and health care. In June 2022, the Milbank Memorial Fund, the foundation that paid the funeral expenses of the deceased study participants as an incentive for their participation, publicly apologized to descendants of the study's victims for its role in the study. The Milbank Memorial Fund conditioned the payment of these funeral expenses on consent by the deceased's descendants to conduct autopsies. These autopsies facilitated the study's ultimate purpose of observing untreated syphilis in African American men. The apology and an accompanying monetary donation to the descendants' group, the Voices for Our Father's Legacy Foundation, were presented during a ceremony in Tuskegee at a gathering of children and other relatives of men who were part of the study. Japanese American mass incarceration. In 1988, the federal government enacted legislation to acknowledge and provide redress for the mass incarceration of Japanese Americans in the United States between 1942 and 1946. The federal government's plan included a cash payment of $20,000 for each surviving incarceree, a program to fund public education of the events, and an apology. In early 1941, the United States Committee on Un-American Activities Committee began investigating Japanese espionage in the United States. The committee, which existed since 1938, was authorized to investigate from time to time 1. The extent, character, and objects of un-American activities in the United States. 2. The diffusion within the United States of subversive and un-American propaganda that is instigated from foreign countries or of a domestic origin and attacks the principle of the form of government as guaranteed by the United States Constitution. And 3. all other questions in relation thereto that would aid Congress in any necessary remedial legislation. The committee's focus on Japan reflected general European and American suspicion of Japanese espionage. A year before the Japanese attack on Pearl Harbor in Hawaii, the United States Army's Signal Intelligence Service broke Japan's highest level diplomatic code. The message appeared to reveal widespread Japanese espionage networks operating along the west coast of the United States, which proved decisive for President Franklin D. Roosevelt's authorization of the mass incarceration of Japanese Americans. On February 19, 1942, President Franklin D. Roosevelt signed Executive Order 9066, incarcerating Japanese Americans and creating a zone, quote, from which any or all persons may be excluded, end quote, at the discretion of the Secretary of War or appropriate military commander from the whole of California, the western halves of Washington State and Oregon, and the southern third of Arizona. By the fall of 1942, all Japanese Americans were forcefully removed from California and sent to one of 10 detention camps built to imprison them. Many incarcerated Japanese Americans lost their property and assets as they were prohibited from taking more than what they could carry with them, and what remained was either sold, confiscated, or destroyed in government storage. The Masuda family, for example, owned the Wanto Grocery in Oakland, California, and proclaimed that they were American even when they were forced to sell their business before they were imprisoned in August of 1942. The Masudas and others were among the tens of thousands of Japanese Americans who were incarcerated in desolate detention camps for up to 4 years. Nearly 70% of those incarcerated were American citizens by birth, and the remaining 30% were Japanese nationals who were legally barred from naturalization because of the de jure racist policies of the time. Many resisted the government-imposed curfews and challenged the constitutionality of the exclusion orders on U.S. citizens based on racial ancestry. However, resistors were convicted for curfew violations, and the United States Supreme Court upheld convictions, arguing the court was not in a position to question claims of military necessity. In the mid-1980s, these convictions were eventually vacated by federal court orders for writ of error coram nobis, which helped spur the passage in 1988, the law that eventually provided a formal apology and redress from the United States to Japanese Americans. In 1948, President Harry S. Truman signed the Japanese American Evacuations Claims Act, 1948 Act, to compensate Japanese Americans for losses incurred at the time of their official removal from the West Coast in 1942. The 1948 Act was the first civil rights associated law enacted in the 20th century. However, the legislation proved largely ineffectual in compensating victims because the claims process placed onerous burdens on them to prove their losses and included a lot of bureaucratic red tape that slowed the claims process to a crawl. Quote, in all, the government paid $38 million to settle damage claims, a fraction of actual losses by Japanese Americans. Many families paid more in lawyers' fees than they received in compensation, end quote. In 1980, Congress and President Jimmy Carter approved the Commission on the Wartime Relocation and Internment of Civilians Commission. The commission was established to 1. Review the facts and circumstances surrounding the relocation and incarceration of thousands of American civilians during World War II under Executive Order numbered 9066 and the impact of that order on American citizens and resident aliens. 2. Review directives of United States military forces requiring the relocation and incarceration of American citizens, including Aleut civilians and permanent resident aliens of the Aleutian and Pribilof Islands. The Aleutian Islands stretch westward for about 995 miles beyond the Alaska Peninsula and southwestern Alaska, separating the Bering Sea from the North Pacific Ocean. The Aleuts occupied this island chain for at least 8,000 years. The Aleut civilian residents of the Pribilof Islands and the Aleutian Islands west of the Unimak Island were removed from their land during World War II to temporary detention camps in isolated regions of southeast Alaska, where they remained under United States control and care until long after any potential danger to their home villages had passed. And 3. Recommended appropriate remedies. In December 1982, the Commission released a unanimous 467-page report titled Personal Justice Denied, detailing the history and circumstances of wartime treatment of the people of Japanese ancestry and the people of the Aleutian Islands. 2 years after the commission was approved, California enacted legislation permitting the filing of claims with the state for salary losses for up to 5 years at $1,000 per year for employees who were dismissed from state service because of their Japanese ancestry. Los Angeles and San Francisco later enacted similar provisions. The Commission's findings and recommendations, along with state and local efforts to provide compensation to the victims, helped bring about the passage of the Civil Liberties Act of 1988 Act. The 1988 Act, which was signed by President Ronald Reagan, provided, quote, redress, end quote, from the nation in the form of $20,000 for each surviving incarceree. Under the 1988 Act, the U.S. Attorney General was charged with identifying and locating eligible individuals within 12 months of the date the 1988 Act was signed. No application was required. The onus was on the Attorney General to complete the identification and notification process. Eligible individuals had the right to refuse payment. If they accepted payment, they had to waive all claims against the government. The 1988 Act allowed for payments to survivors of eligible individuals who were deceased, priority payments to the oldest eligible individuals, and tax treatment that excluded payments as income under the Internal Revenue laws. By 1999, the redress payments had been distributed to approximately 82,220 claimants. About 30 lawsuits were filed against the United States by those who had been found ineligible for redress. A later settlement on a lawsuit filed by Japanese Latin Americans resulted in $5,000 redress payments for those claimants. To operationalize the 1988 Act, the federal government established the Office of Redress Administration, ORA, located within the Civil Rights Division of the Department of Justice. The ORA had 10 years to complete its work from the date the Act was signed. At its peak, the ORA had around 100 employees. Because the 1988 Act only authorized redress payments and did not itself appropriate funds, separate appropriations had to be secured from Congress. By 1990, only $20 million were available for redress payments, or about 1.6% of the amount authorized. Congress later resolved the issue by amending the 1988 Act, requiring the necessary funds to be appropriated. The ORA worked to build trust within the community, working with Japanese American organizations, including the Japanese American Citizen League and the National Coalition for Redress Reparations. It organized redress check ceremonies throughout the country and held workshops to meet community members and disseminate information on the redress program. As the life of the ORA drew to an end, the remaining focus turned to paying on claims that had initially been denied, or locating recipients who had not responded to outreach. The ORA prioritized the oldest living recipient. Cases that were initially denied and subsequently reviewed for reconsideration included Japanese Latin Americans, children of, quote, voluntary evacuees, end quote, minor children who had gone to Japan with their families, and those Japanese Americans who lived in Hawaii and were excluded from their homes but weren't necessarily incarcerated. In some cases, where written documentation did not exist, the ORA was able to approve redress claims based on affidavits by contemporaneous witnesses. The 1988 Act also established the Civil Liberties Public Education Fund, within the U.S. Treasury, which was to be administered by the Secretary of the Treasury and used for disbursements by the Attorney General and the newly established Civil Liberties Public Education Fund Board of Directors. The Public Education Fund initially received appropriations totaling $1,650 million, and the Public Education Fund's purpose was, quote, to sponsor research and public educational activities and to publish and distribute the hearings, findings, and recommendations of the Commission so that the events surrounding the evacuation, relocation, and internment of United States citizens and permanent resident aliens of Japanese ancestry will be remembered." End quote. The Public Education Fund would terminate once the funds appropriated to it were exhausted, or 10 years after the enactment of the 1988 Act. Additionally, all documents, personal testimony, and other records created or received by the Commission during the inquiry were kept and maintained by the Archivist of the United States, who was directed to preserve such documents, testimony, and records in the National Archives of the United States and make them available to the public for research purposes. The Act also called upon each department and agency of the U.S. government to review with, quote, "liberality," end quote, giving full consideration to the findings of the Commission, any application by an eligible individual for restitution of any position, status, or entitlement lost because of any discriminatory act of the U.S. government against those of Japanese ancestry during the period of internment. Finally, the Act provided a formal letter of apology for each surviving incarceree. President George H.W. Bush signed the first letters of apology in 1990. One such letter from President Bush read, "A monetary sum and words alone cannot restore lost years or erase painful memories. Neither can they fully convey our nation's resolve to rectify injustice and to uphold the rights of individuals. We can never fully right the wrongs of the past, but we can take a clear stand for justice and recognize that serious injustices were done to Japanese Americans during World War II. In enacting a law calling for the restitution and offering a sincere apology, your fellow Americans have, in a very real sense, renewed their traditional commitment to the ideals of freedom, equality, and justice. You and your family have our best wishes for the future." September 11, 2001. The federal government passed legislation in 2004, 2011, and 2019 to compensate victims of the September 11, 2001 terrorist attacks. Congress's plan includes a victim compensation fund where victims who have a physical injury or condition caused by the terrorist attacks can file claims for pain and suffering and past and future lost earnings. The militant Islamic network, Al-Qaeda, carried out 4 coordinated suicide terrorist attacks against the United States on September 11, 2001, commonly known as 9/11. Terrorists hijacked 4 commercial airliners and crashed 2 planes into the Twin Towers of the World Trade Center in New York City, 1 plane into the Pentagon in Arlington, Virginia, and 1 in a field in Shanksville, Pennsylvania, that was intended to hit a federal government building in Washington, D.C. Nearly 3,000 people died in the attacks. The incineration of the Twin Towers and the crashed aircrafts on September 11, 2001, released clouds of noxious toxins at each of the crash sites. First responders, volunteers, and residents near Ground Zero inhaled harmful dust, smoke, toxic chemicals, and particle remnants. This toxic exposure subsequently caused various illnesses, including more than 60 types of cancer, respiratory conditions, and digestive disorders. Thousands of survivors and first responders have been diagnosed with 9/11-related illnesses, and thousands more have died. The compensation provided to 9/11 victims and their families or representatives addresses the damages from both the terrorist attacks and the cleanup efforts. Almost immediately after the September 11, 2001 terrorist attacks, Congress passed the Air Transportation Safety and Stabilization Act, which enacted the September 11th Victim Compensation Fund, VCF. The bill was enacted to bring financial relief to any individual or relative of a deceased individual who was physically injured or killed as a result of the terrorist attacks. The claims window for this first round of funding under the VCF, or, quote, VCF1, end quote, closed in 2004. The VCF was reopened on January 2, 2011, when President Barack Obama signed the James Zadroga 9/11 Health and Compensation Act of 2010, the Zadroga Act. While VCF1 only covered the victims or their representatives who were either killed or injured as a direct result of the 9/11 terrorist attacks. The Zadroga Act expanded the VCF to compensate victims for injury or death related to the debris removal process conducted in the aftermath of the terrorist attacks and to exposure to the toxic air in Lower Manhattan and the other crash sites during that time. Eligible individuals must have been present at the World Trade Center, the surrounding New York City exposure zone, the Pentagon crash site, or the Shanksville, Pennsylvania crash site at some point between September 11, 2001 and May 30, 2002, and diagnosed with a 9/11 related illness. Compensation was available to first responders, those who worked or volunteered in construction, cleanup, and debris removal, and people who lived, worked, or went to school in the exposure zone. The claim filing deadline was in 2016. The 2011 Zadroga Act also established the World Trade Center, WTC, health program to provide medical monitoring and treatment for responders and survivors with chronic health conditions arising from the 9/11 attacks. Unlike the VCF, the WTC health program covers mental health conditions. The WTC health program is administered by the Director of the National Institute for Occupational Safety and Health, NIOSH, and conducts scientific research to better identify, diagnose, and treat physical and mental health conditions related to 9/11 related exposures. In 2015, the Zadroga Act was reauthorized and extended until December 2020. Certain award calculations were changed. The original VCF paid an average death claim award of over $2 million and awarded anywhere from $500 to over $8.6 million in personal injury claims. Due to budgetary concerns, the reauthorization of the Zadroga Act in 2015 restricted victim compensation. It capped awards for non-economic loss from cancer conditions at $250,000, awards for non-economic loss from non-cancer conditions at $90,000, and awards for economic loss of annual income at $200,000. In early 2019, the VCF announced reductions to claim awards by 50 to 75% because of insufficient funds. Outraged, the public demanded increased funding, and Congress held hearings on fund and claim deadline extensions. In July of 2019, Congress passed the Never Forget the Heroes James Zadroga, Ray Pfeiffer, and Luis Alvarez permanent authorization of the September 11th Victim Compensation Fund Act, VCF Permanent Authorization Act, fully funding the VCF as necessary to pay all eligible claims through the extended filing deadline of October 1st, 2090. It also compensated any victims who received reduced awards due to budgetary restrictions with the full value of their award. Now, to receive compensations, claimants must meet two deadlines, the registration deadline and the claim deadline. For both personal injury and deceased claims, a new or subsequent government determination that a condition or injury is 9/11 related triggers a 2-year registration window. The 2-year time frame applies when claimants know of both the physical injury and its causal connection to 9/11. Registration alerts VCF of a potential claim and preserves the right to file the claim in the future. Claimants can still register prior to having a diagnosis that their injury or condition is 9/11 related. If registration is timely for any conditions or injury, then all eligible conditions are considered for the claim. The VCF was designed to be a compensation scheme in lieu of tort litigation for the economic and non-economic losses incurred by victims who were physically injured and families of victims whose lives were taken as a result of the terrorist attack. Claimants who participate in this compensation scheme waive their right to sue for damages for injury or death as a result of the terrorist attack. A compensation fund was chosen as an alternative to potential class action toxic tort litigation because it is more efficient and effective solution for compensating victims. The VCF was enacted to relieve victims and their families from navigating through the legal system and possibly having their claims rejected under government immunity or other potential bars. The VCF is administered by the U.S. Department of Justice. To be eligible for compensation from the VCF, claimants must have a physical injury or condition caused by the 9/11 terrorist attack or by the rescue, recovery, and debris removal efforts during the immediate aftermath of the attacks. Claimants must have at least one of the predetermined WTC-related physical health conditions in order to be eligible. Claimants must demonstrate a diagnosis through a private physician process and/or a WTC health program. After a diagnosis, claimants then fill out a claim form that includes eligibility and compensation information and attach certain supporting documents to demonstrate presence at a 9/11 crash site, at a debris removal route, or within the exposure zone. Examples of acceptable documentation include sworn affidavits, medical records, lease or mortgage documents, and employer letters. The VCF first reviews the claim for eligibility, and if approved, the VCF then reviews the losses claimed for compensation. At the claimed losses stage, the VCF reviews non-economic loss, pain and suffering, based on the severity of the physical harm and reviews economic loss based on past and future lost earnings. Once the total amount of the compensation is calculated, the claimant is informed of the outcome and has an opportunity to appeal within 30 days. If no appeal is exercised, then the U.S. Treasury authorizes the payment and disperses it to the bank account designated in the claim application. The most significant issue with implementation has been the consistent capitalization of the fund. Over the past 2 decades, the fund struggled to meet rising medical costs and cancer rates. Many exposure symptoms and 9/11 related diseases took years to manifest. Additionally, as described above, the fund went through various iterations of funding and scope throughout its lifetime. Another issue has been claimants providing inadequate documentation for their claim or filing premature claims. According to the VCF's 2022 annual report, 54% of claims are deactivated for failure to provide the minimum required information. 41.9% of all claims are submitted with insufficient proof of presence documents, and 32.3% do not have a certified physical condition at the time the claim is filed. Sandy Hook Elementary School. In the years following the 2012 Sandy Hook Elementary School shooting, one of the deadliest in U.S. history, the Federal Departments of Justice and Education issued several grants to establish a new Sandy Hook school at a vacant campus, to hire and train staff, including mental health professionals, and to help staff private charities that were handling donations intended for victims and victims' families. On December 14, 2012, Adam Lanza shot and murdered 20 children and 6 adult staff members, including the school principal and school psychologist, at Sandy Hook Elementary School in Newton, Connecticut, after killing his mother. Lanza had gathered an AR-15, 2 semi-automatic pistols, as well as several hundred rounds of ammunition stored in high-capacity magazines. His mother had purchased several of the guns. When he arrived at the school, he shot and killed the school's principal and school psychologist. Teachers who heard the gunshots entered the lockdown procedures, but Lanza was able to enter the classroom where he killed the teacher and 14 children. He entered a second classroom and killed the teacher and 6 students. He also killed a special education aide and a behavioral therapist. When police arrived at the school, they discovered that Lanza had killed himself. It is the deadliest mass shooting at an elementary school in U.S. history and the second deadliest school shooting overall. The school was demolished in 2014 and replaced by a new building in 2016. On January 3, 2013, Connecticut Governor Dannell P. Malloy established the Sandy Hook Advisory Commission to investigate the facilities, recommend public policy implementation, and recommend law enforcement reforms. The commission found that Lanza acted alone, but did not identify a motive. The commission made several recommendations, including investment in mental health professionals and funding for short-term and long-term recovery plans and behavioral health and education responses to crisis events. At least $28 million was raised by more than 77 charities in the years after the shooting, with about a quarter of that amount distributed to families by the end of 2014. Families settled a lawsuit with Remington, the manufacturer of the gun used by Lanza, for $73 million and won judgments of $965 million and $473 million against Alex Jones, the founder of InfoWars, for defamation, infliction of emotional distress, and violations of Connecticut's Unfair Trade Practices Act. The federal Departments of Justice and Education have awarded several grants to supplement these funds. A Hartford Courant review found that the federal government had given the town of Newton and several agencies related to Sandy Hook over $17 million in aid, used primarily to enhance mental health services and school security in the 2 years following the shooting. Much of the money from the grants went directly to opening the new Sandy Hook Elementary. On December 17, 2013, the U.S. Department of Justice Office for Victims of Crime granted $1.5 million to the Connecticut Judicial Branch to reimburse organizations and agencies that provided direct support to victims, first responders, and the Newton community. The grant provided reimbursements for costs incurred by organizations that provided crisis intervention services, trauma-informed care, victim-related law enforcement support, and costs incurred in moving students from Sandy Hook to a new school location. The grant was distributed through the Anti-Terrorism and Emergency Assistance Program, which grants awards for crisis response and is funded by the Crime Victims Fund for the Anti-Terrorism Emergency Reserve Fund. The Department of Justice also provided $2.5 million in funding for Connecticut and Newton law enforcement agencies through the Bureau of Justice Assistance. In June 2014, the Department of Justice issued another grant for $7.1 million through its Office for Victims of Crime. This grant was for victim services, school safety efforts, and new mental health services. Additionally, the town of Newton and the state received $2.5 million from the Department of Justice for police overtime costs. The federal funding was split between several groups. Newton Recovery and Resiliency Plan received $826,443. $618,000 went to hiring 4 full-time staffers. The second group, Resiliency Center of Newton, received $501,000, with $408,000 used for hiring therapists. The United Way of Western Connecticut received around $131,355 from the Department of Justice, of which half was spent to hire a lobbying firm for public relations. The Sandy Hook Foundation used $122,000 of the funds to hire an executive director. School Emergency Response to Violence, SERV, grants from the Department of Education totaled $6.4 million. $1.3 million was earmarked for mental health providers working with student survivors. The rest was used to hire teachers, security guards, and other personnel. In total, the federal government has given $17 million in additional aid for mental health services and school security. The grants were designed to strengthen the aid infrastructure and create programs that will aid in the recovery process for many years. Immediately after the shooting, there was an increase in crisis referrals for mental health assistance, an increase in chronic absenteeism, and an increase in school nurse visits. Parents and community members criticized the fund's disbursement process since most of the grants were for support services and none of the federal money was designated for survivors or their families. Parents have said in public meetings that, quote, trying to get help has been at best confusing and at worst impossible for many families, end quote, and that the advertised supports were inaccessible and difficult to identify. Some have also argued that the funds have gone towards hiring public relations and lobbying firms rather than going to direct aid. The Sandy Hook Foundation, for example, raised $12 million for victims' families through private donations and distributed only $7.7 million without accounting for the rest. The Department of Justice still granted the foundation $173,830, most of which was used to pay the salary of the director. Iranian hostages. In 2015, Congress created the United States Victims of State-Sponsored Terrorism Fund to compensate American diplomats and staff who had been abducted and held hostage by Iranians at the U.S. Embassy in Tehran for 444 days between 1979 and 1981. Each former hostage is entitled to receive $10,000 for each day they were held in captivity. Spouses and children of the former hostages are entitled to a lump sum of $600,000 each. However, due to issues with funding, the former hostages and their families have yet to receive the entire amount each are due. On November 4, 1979, a group of 3,000 Iranians stormed the U.S. Embassy in Tehran and took 63 American men and women hostage. The seizure took place shortly after the Iranian Revolution. Mohammad Reza Shah Pahlavi, the previous ruler of Iran, who was deposed in January of 1979, had been a close ally to the U.S. After he was deposed, the revolutionary government treated the U.S. cautiously and suspiciously. The U.S. Embassy had been the scene of frequent demonstrations by Iranians who opposed the American president's Iran. And on February 14, 1979, the embassy was attacked and briefly occupied by guerrillas, trapping the U.S. ambassador, William H. Sullivan, and 100 members of his staff inside. The ambassador called on Ayatollah Khomeini, the revolutionary leader of Iran, for help. Khomeini's forces freed the hostages, but several personnel were wounded or killed. No compensation program has been proposed for the February 14th hostages. In October 1979, the Shah Pahlavi traveled to New York City to obtain medical treatment. U.S. authorities informed the Iranian Prime Minister, Mehdi Bazargan, of the trip, and Bazargan guaranteed the safety of the U.S. Embassy and its staff from potential retaliation for Americans welcoming the deposed ruler. The leaders of the storming of the embassy, a group of about 60 Iranian university students who called themselves the Students Following the Imam's Line, demanded that the Shah be returned immediately to face the revolution. In the following days, the Carter administration and diplomats from other countries attempted but failed to negotiate the release of the hostages. On November 12th, acting Foreign Minister Abul Hassan Banir Sadr proposed a release of the hostages if 1. The United States ceased interfering in Iranian affairs, 2. The Shah was returned to Iran for trial, and 3. Assets in the Shah's possession were declared stolen property. The U.S. responded by stating that it would support establishing an international commission to investigate human rights abuses under the Shah's regime, and by refusing to purchase Iranian oil, instituting an international economic embargo against Iran, and freezing billions of dollars in Iranian assets in the United States. On November 17, 13 hostages, all women or African Americans, were released on orders of Khomeini on the grounds that they were unlikely to be spies. On April 24, 1980, a small group of special operations soldiers attempted to free the hostages by force. Their mission failed. However, when 3 of the 8 helicopters malfunctioned, U.S. forces withdrew and 1 helicopter crashed. 8 U.S. service members were killed. No diplomatic progress was made until later in the year. In mid-August, Iran implemented a permanent government. In September, Iraq invaded Iran. The economic embargo and Iran-Iraq war led to Iran re-engaging in hostage negotiations. Algerian diplomats eventually brokered an agreement, the Algiers Accord, and the hostages were released on January 20th, minutes after the inauguration of Ronald Reagan. The hostage crisis is widely believed to have contributed to Reagan's victory over Carter. The Algiers Accords included, among other items, a provision preventing the hostages from seeking compensation from Iran in U.S. courts. As a result, former hostages and their families have never successfully won judgments or collected damages from the harms of the hostage crisis. The Hostage Relief Act of 1980, passed during the crisis, did not provide a cash payment to former hostages or their families, but did provide other benefits, including the creation of an interest-bearing salary savings fund, including retroactive interest, reimbursement of other medical expenses, extension of various forms of service members' relief to hostages, tax relief, including deferred assessment of taxes for the period of captivity, and refunding of tax collected prior to enactment of the Act, and educational expenses for family members and hostages. A proposal to provide each hostage with $1,000 per day of captivity to be funded by frozen Iranian assets was rejected by the State Department on the grounds that it would complicate negotiations. On the same day that the Algiers Accords were signed, President Carter created the President's Commission on Hostage Compensation with the goal of providing recommendations on financial compensation to former hostages. The Commission issued a report that the United States, as the employer of the former hostages, should not be held liable in a, quote, tort sense, end quote, but that the former hostages should receive a payment of tax-exempt detention benefits in the amount of $12.50 per day of captivity, similar to the benefits paid to Vietnam War prisoners of war. These recommendations were debated in Congress, but ultimately not adopted. In 2015, Congress passed the United States Victims of State-Sponsored Terrorism Act, establishing a fund through the Consolidated Appropriations Act of 2015. The fund initially included an appropriations for $1.25 billion for fiscal year 2017. Further funding has been provided by proceeds of federal enforcement actions. At the time of the passage, 37 former hostages were still alive. Each hostage is entitled to receive $10,000 per day of captivity, and spouses and children are each entitled to a lump sum of $600,000. Some of the appropriated money came from a $9 billion penalty assessed on Paris-based bank BNP Paribas for violating sanctions against Iran, Sudan, and Cuba. In November 2019, Congress enacted the United States Victims of State-Sponsored Terrorism Fund Clarification Act, amending the original legislation by extending the life of the fund and expanding eligibility to receive payments from the fund. The Consolidated Appropriations Act of 2021 again amended this legislation. An eligible claimant was originally statutorily limited to a U.S. person with a final judgment issued by a U.S. District Court under state or federal law against a state sponsor of terrorism and arising from an act of international terrorism. A U.S. person who was taken and held hostage from the United States Embassy in Tehran, Iran, from the period beginning November 4, 1979 and ending January 20, 1981, or the spouse and child of that person, and who is also identified as a member of the proposed class in case number 100CV03110 EGS of the U.S. District Court for the District of Columbia, a personal representative of a deceased individual in either of the two categories. On May 17, 2016, the Attorney General appointed Kenneth R. Feinberg as the Special Master to administer the fund. The Clarification Act removed the requirement that the former hostage be identified as a class member of Rotor 1, but the requirement remains for the hostage's spouse's children. Former hostage applicants for the fund were required to apply by October 12, 2016. Each applicant needed to establish eligibility. Former hostages were required to verify their identities and the date that they were released. Spouses were required to verify that they were married to the former hostage during the hostage period, and children were required to produce birth records showing that they were born before January 20th, 1981. The Special Master has ultimate authority over compensation of the fund, and their decisions are not subject to administrative or judicial review. A claimant whose claim is denied may request a hearing before the Special Master within 30 days of the receipt of the denial. The Special Master hosted 2 telephonic town hall meetings to provide potential claimants, their lawyers, and the public with the opportunity to ask questions concerning the Act, and the Special Master also met personally with victims' advocates. The Special Master extended the application deadline to December 2, 2016, and received a total of 2,883 applications for both the former Iran hostages and their families and those who had received eligible judgments. By August 2017, $1 billion had been disbursed. The fund distributed another $1 billion between 2017 and 2019, and another $1.2 billion between 2019 and 2022. As of the 2023 report, $107.8 billion in compensatory and statutory damages remained unpaid for the former hostages, other individuals eligible for compensation from the fund. The fund is scheduled to terminate in 2039, and the special master will authorize annual payments if sufficient funds are available. The act was amended in 2019 to include the 9/11 victims who had won judgments against Iran, and the fund was converted to be dispersed on a pro rata basis. Following the amendment, the fund was to be divided in half to be provided for 9/11 related victims of state-sponsored terrorism and half to non-9/11 victims. The half allocated to non-9/11 victims is further divided on a pro rata basis, based on the amounts outstanding and unpaid on eligible claims until such amounts are paid in full. As a result of the inclusion of 9/11 related claimants for the fund, only a fraction of the amount designated for former hostages and their families has been distributed. The former hostages have received occasional payments. Fund administrators estimate that the non-9/11 beneficiaries, including the former hostages, have received about 24% of what they are eligible for. As of September 26, 2021, only 35 hostages remained alive. As long as the fund is maintained and there are outstanding payments, the special master will authorize payments on an annual basis. The fund sunsets on January 2, 2039. State and local reparatory efforts, Rosewood, Florida. The Florida legislature passed a claim bill in May 1994 to acknowledge and provide redress for the destruction and massacre of Rosewood, Florida, a small, predominantly African American community with approximately 120 residents that had wealth in the form of homes and businesses. Florida's restitution to victims included approximately $2.1 million in compensation at a state scholarship fund for direct descendants. The decimation of Rosewood started on January 1, 1923, when a white woman named Fannie Taylor reported an attack by an unidentified African American man in the town next to Rosewood. Many African American descendants of Rosewood contend that the, quote, attack, end quote, was a cover-up for a visit from her white lover. Hearing the report from Taylor, a white vigilante mob led by Levy County Sheriff Robert Elias Walker descended upon Rosewood. The mob tortured and killed an African American man named Sam Carter. For the next week, hundreds of white vigilantes arrived in Rosewood. They burned every home and building structure, such as churches and schools, murdered 6 African American residents, and wounded dozens more. 2 white men also died in a shootout. News of the, quote, race war, end quote, traveled quickly throughout the state and country, but the Florida governor never sent in the National Guard to protect African American residents and end the violence. Many of Rosewood's African American residents fled to the nearby swamps and hid during the riots. A rescue train evacuated fleeing residents to Gainesville. At the end of the violence, only the house of John and Mary Jane Hall Wright, the white residents of Rosewood, remained standing. On February 12, 1923, a grand jury convened on Bronson, Florida, to investigate the Rosewood massacre. 4 days later, the grand jury found insufficient evidence to prosecute. African American residents never returned to Rosewood. In 1994, restitution to Rosewood victims passed the Florida House of Representatives as a claim bill, sponsored by Representative Miguel DeGrady. A claim bill provides compensations to those injured by an act or omission of the state, its subdivisions, agencies, officers, or employees. The bill, quote, recognized an equitable obligation to redress the injuries as a result of the destruction of Rosewood, end quote, and consisted of 1, the finding of facts, 2, a direction to the Florida Department of Law Enforcement to conduct a criminal investigation in and around the Rosewood incident. 3, $500,000 to be distributed from the General Revenue Fund to African American families from Rosewood to compensate for demonstrated property loss. 4, compensation of $150,000 from the General Revenue Fund for each of the 9 living survivors. 5, the establishment of a state scholarship fund for direct descendants of Rosewood families. 6. A direction to the state university system to continue researching the Rosewood incident and the history of race relations in Florida and develop educational materials about the destruction of Rosewood. After weeks of sensation in the news following the violence in January 1923, the story of the Rosewood Massacre disappeared from public media as survivors largely never spoke of the event. In 1982, investigative reporter Gary Moore from the St. Petersburg Times unraveled the history of Rosewood in a comprehensive article that later became a story on CBS's 60 Minutes. The media attention galvanized Arnett Doctor, a descendant of Rosewood residents who had been gathering the history of Rosewood for years. Doctor was the driving force behind Rosewood becoming a public issue. He secured the counsel of Holland and Knight to help descendants and victims seek compensation from the state for the violence and destruction of Rosewood. With the firm's help, former Rosewood residents and their descendants were named in a claim bill, alleging physical and emotional suffering that resulted from acts or omissions of law enforcement and other county and state officials. However, they missed the filing deadline for the 1993 session, so the bill was not introduced. This year, however, 2 other bills addressing Rosewood's history were introduced and failed to pass. Nonetheless, coupled with the public pressure, the failed bills paved the way for the communication of an academic report that substantiated the claims of Rosewood descendants. Chaired by Dr. Maxine Jones of the Florida State University Department of History, the team issued its December 1993 report, a documented history of the incident which occurred at Rosewood, Florida in January 1923. Opponents attacked the report as hearsay. One of the authors of the report admitted that, quote, perhaps the most damaging charge against the historical report was that it failed to include statements or interviews by accused whites or their friends or relatives, end quote. But white people in the area refused to be interviewed for the report and were even hostile to the historians in some instances. The historical report was enough evidence to support an equitable cause of action, even if it might not have survived scrutiny in a court proceeding. The claim bill for compensation was reintroduced in the legislative 1994 session, and hearings were held to elicit testimony from Rosewood survivors. At the hearings, survivors and expert witnesses testified about the post-traumatic stress disorder symptoms and other suffering from violence of the Rosewood Massacre. When the bill was on the state floor, opponents attacked the bill with similar arguments. The violence was over 70 years ago. There was a lack of definite evidence of who committed the harms, and there was a fear that passing this bill would set a precedent for other groups injured in Florida's past to make claims. The equitable nature of the claim bill served as a retort to these arguments, since claim bills were not precedential. The bill passed on May 4, 1944. The House vote was 71-40, and the Senate vote was 26-14. The flexibility of a claim bill was critical to the descendants' success in securing compensation. If the descendants had asked for compensation in a claims proceeding in a court of law, their case would have been barred by hearsay or statutes of limitations. But since the claim bill hearing was an equitable proceeding, the legislature was not bound by those rules of law. Restitution for the Rosewood Massacre became a moral issue for Florida, thus securing its passage even if it could not have been adjudicated in a court of law. Additionally, advocates of the bill were careful not to use the word, quote, reparations, end quote, during discussions seeking compensation, and the word cannot be found in the bill. This was done in order to achieve passage of the bill. Attorneys at Holland and Knight focused the bill on private property rights and the moral obligation Florida had to Rosewood victims and descendants. The Rosewood Family Scholarship is codified in the state's education code, and the Florida Department of Education promulgated the criteria to receive an award. The Rosewood Family Scholarship provides student financial assistance to a maximum of 50 students annually and currently provides up to $6,100 per student per academic year. To be eligible, applicants must be direct descendants who complete a Florida financial aid application, provide documentation of ancestry such as a birth certificate, marriage license, death certificate, church record, or obituary, and enroll in a state university, Florida college system institution, or career center authorized by law. Applicants are selected based on need. The General Appropriations Act provides funding for the scholarship program. The scholarship award is distributed before each semester's registration period on behalf of the student to the president of the university or Florida College System's institution, his or her representative, or to the director of the Career Center where the recipient is attending. Since the bill's enactment, there have been no notable issues with implementation. Some recent scholarship recipients have noted the pressure of Rosewood's history looming over them on campus, resulting in a sense of purpose and worry about upholding the legacy of their ancestors. In 2004, a Florida historical marker, co-sponsored by the state and the Real Rosewood Foundation, a nonprofit dedicated to preserving the history of Rosewood, was placed on State Road 24 to note where the community once was. It states, quote, "Those who survived were forever scarred," end quote. North Carolina sterilization. In 2002, Governor Mike Easley apologized for forced sterilizations performed under the purview of the state of North Carolina's Eugenics Board. In 2013, North Carolina was the first state to pass legislation to compensate victims of state-sponsored eugenics sterilization. The law set aside a $10 million pool for compensation payments, and at least 215 victims received $20,000 in 2014, $15,000 in 2015, and a final payment of around $5,000 in 2018. In 1919, North Carolina passed its first forced sterilization law, which was amended in 1929 to allow the head of any penal or charitable institution that received even some state funding to have, quote, "have the necessary operation for asexualization or sterilization performed upon any mentally defective or feeble-minded inmate or patient thereof," end quote. The North Carolina Supreme Court invalidated the law in 1933 because it failed to provide any notice or opportunity for appeal. In response, the North Carolina legislature created the North Carolina Eugenics Board to implement the new forced sterilization law that had very limited appeal rights. The 5 members of the board heard petitions brought by heads of state institutions, county superintendents of welfare, next of kin, or legal guardians arguing the individuals should be sterilized due to being either epileptic, quote, feeble-minded, end quote, or mentally diseased. There was a very limited appeal process, and the board approved about 90% of the petitions. The state ultimately sterilized around 7,600 persons, the third largest number in the country. The program was somewhat unique in that it also sterilized non-institutionalized individuals, not just those residing in penal or mental facilities. Moreover, the vast majority of the sterilizations took place after World War II. Governor Bev Perdue established the North Carolina Justice for Sterilization Victims Foundation as part of the North Carolina Department of Administration in 2010 to function as a clearinghouse to help victims of the former North Carolina Eugenics Board. During 2011 and 2012, the foundation also supported the separate gubernatorial task force on eugenics compensation established under Executive Order 83. This effort culminated in the state legislature creating the Eugenics Asexualization and Sterilization Compensation Program in 2013. The statute set out a program to compensate individuals who were asexualized or sterilized involuntarily under the authority of the board under either the 1933 or 1937 version of the law. This requirement that the state board have been involved in and or have a record of the sterilization caused implementation issues, as it turned out that many individuals were sterilized at the county level without the involvement of the state board. A sterilization was, quote, involuntary, end quote, under the statute if done in the case of 1, a minor child with the consent of the child's parent or guardian, 2, an incompetent adult, with or without the consent of the adult's guardian or with a court order, or 3, a competent adult without the adult's informed consent, but with the presumption that the adult gave informed consent. A claimant must also have been alive on June 30th, 2013 in order to receive compensation. The state legislature allocated $10 million to pay compensation claims. The first payment was to be made to those claimants deemed qualified by October 31st, 2014. Any claimants determined to be qualified recipients after that date were to receive their initial payment within 60 days, and final payment checks splitting the remaining funds among the qualified recipients were to be sent out within 90 days of the exhaustion of the last appeal. Applications needed to be received by September 23, 2014, in order to be considered for the program. Now, Senator Tom Tillis was a co-sponsor of the legislation while he was North Carolina Speaker of the House. Discussing the need for financial payments, Tillis stated, quote, "We decided that we were going to take the hits and do the right thing for the victims. It was not easy. We had opposition from both sides, some saying we shouldn't do it at all, others saying we weren't doing enough. But those have been the arguments that first prevented it from happening in the past, and we decided that we were going to push through and do the right thing for the victims." End quote. The bill specifically stated that financial compensation would not be subject to tax and other limitations. 1. Any payment should not be considered income or assets for purposes of determining the eligibility for or the amount of any benefits or assistance under the state or local program financed in whole or in part with state funds. And 2, the North Carolina Department of Health and Human Services should disregard compensation money in the determination of public assistance or recovery of Medicaid-paid services. Once he became a United States Senator, Tillis authored a bill to protect compensation payments from any determination for federal benefits. North Carolina only appealed its sterilization law in 2003. As part of the repeal, then Governor Easley issued a public apology. He stated, quote, "To the victims and families of this regrettable episode of North Carolina's past, I extend my sincere apologies and want to assure them that we will not forget what they have endured." End quote. The state creating the compensation program formed the Office of Justice for Sterilization Victims in the North Carolina Department of Administration to administer claims. Applicants were able to submit claims to the office between until June 30, 2014. Claims needed to be dropped off in person or mailed and be received by the above date to be considered. Claims were assessed by the North Carolina Industrial Commission. A deputy commissioner first assessed the claims to determine eligibility, and if the claim was not approved, the deputy commissioner had to set forth in writing the reasons for the denial and notify the claimant. If not approved, a claimant could submit additional documentation and request redetermination by the deputy commissioner. A claimant whose claim was not approved at either previous stage or the right to request a hearing before the deputy commissioner, where the claimant could be represented by counsel, present evidence, and call witnesses. The deputy commissioner who heard the claim had to issue a written decision of eligibility. A claimant could then file a notice of appeal with the commission within 30 days. Such an appeal was to be heard by the full commission, and the commission had to notify all parties concerned in writing of its decision. A claimant could appeal the decision of the full commission to the State Court of Appeals within 30 days of the date of notice of the decision given. Decisions favorable to the claimant were final and not subject to appeal by the state. If a claimant was determined to be a qualified recipient, the Commission gave notice to the Office of Justice for Sterilization Victims and the Office of State Controller. The Office of State Controller then made a payment of compensation to the qualified recipient. Compensation was intended to be in the form of 2 payments, with the first by October 31, 2014, or 60 days after a claim was approved, if approval happened October 31, 2014, and the second payment after the exhaustion of all appeals arising from denial of eligibility. Several court cases appealing denials of claims took several years to progress through the courts. So the state ultimately sent 3 payments to victims between 2014 and 2018. There were 2 groups of court cases regarding who qualified as a claimant under the program. First, a group of plaintiffs argued they should be eligible for compensation payments as heirs to victims of sterilization. The state court ruled it was not an equal protection violation for the statute to provide compensation only to those victims alive on the date the statute was passed. Second, a group of plaintiffs challenged the limitation of compensation to only those whose sterilization was directly under the auspices of the State Eugenics Board, rather than a county official or state judge. the state court eventually ruled that the plaintiff's equal protection claim lacked merit. And that will conclude tonight's reading of Chapter 15 of the California Reparations Task Force's final report. We ended on page 584. Our next reading will resume on page 584 at the Virginia Eugenics section. That will be next Thursday at 7 p.m. We hope you'll join us. You can listen to the recordings anytime. Please share with your family, friends, and colleagues. Before you go, if you haven't done so already, please remember to like this video, hit the bell for reminders, and subscribe to our YouTube channel. When you go, please remember to get connected. Follow CJEC on all social media, Instagram, TikTok, Facebook, and X, formerly known as Twitter, at CJEC Official. Get informed. Visit www.cjec-official.org and sign up for current and accurate California reparations news and information at our Get Involved page. Get involved. Support our work by volunteering and/or donating. To donate, please click the Donate tab on the home page of our website. A special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. Learn more about them at www.cabwhp.org. Thank you again for today's sponsors, the Plunkett and Bell families, in honor of Joyce Agnes Richmond of Chicago, Illinois. Rest in power, Aunt Joyce. We love you. We also thank all other listeners who have donated. We are closer to reparations than we have ever been in California. Audience, I appreciate your time and your attention. This is difficult information to hear. I ask that you please practice self-care as you see fit. I look forward to part 4 of Chapter 15 next Thursday at 7 p.m. That will conclude Chapter 15. Have a great night. Peace and reparations.